particularly unattainable as a performance measure, it could be a real challenge to figure out. JPEG will probably look at the statute because they're a creature of statute in so many ways, and so I don't know if we'll have to figure that out, but that will likely pass, I would assume, at some point in the next 2 weeks.
One question on that. Is there anything in that about us reporting differently some of the metrics to JPEG?
There's nothing specifically in the bill that requires us to report anything different to JPEG. There are a number of probably new vectors that bring implication to the changes in the bill we may have to. For instance, that it makes more official, although I think JPEG has already been doing some of this, the interviewing of parties to a case as part of the surveying that JPEG does. They've been exploring how to survey parties to a case. For some time, Mary Margaret would have known better if she were still here. They don't have the ability to do that wholesale or full scale at this point. It's just resources wise. We may have to communicate some additional data though to JPEG if they ramp up the surveying of parties, so that they can do so in the time limit specified in statute, things like that. But it doesn't explicitly state that we have to do that.
And so did Senate Bill 233, does that include the timelines for district courts as well?
No, just at this point, Court of Appeals and Supreme Court. It's a little frustrating, I have to say, because we met with Senator Brammer in the summer and fall of last year, and he raised the issue of it seems strange that in the appellate court context, the appellate court judges, particularly in his mind, the Supreme Court, have a static number of cases that can be outside the timelines and still meet the criteria. And when opinion numbers are way down, like they were post-COVID and with transition of justices, and there were 26 opinions in 2023, I think, that would mean that for each of the justices on the Supreme Court, they could have more than half of their work outside of the timelines and still comply with their performance standard. And he observed and said, shouldn't it just be a ratio, a percentage of cases? So we took that on, and the Supreme Court, the Court of Appeals, the Board of Appellate Court judges grappled with making some proposed changes that would change it from a static number of opinions to a ratio. And we were trying to be responsive to him, and then he said, thank you very much, and then he wants to put it into statute. So I think what we've learned is sometimes if an issue is identified and we're asked to try and find a solution, I don't know why we would want to try and find a solution when our solution then gets picked up and put into a statute where we didn't. It's a little disincentivizing. Anyway, yeah. Okay, let's talk about a few other bills that are a big deal, and then I'll stop talking. There are 3 that have already passed. You talked about 2 of them through the panel district court judges, House Bill 392 and then the corollary Senate Joint Resolution 5 that changes the rules of procedure around that. So you're already aware of those things. I've been asked by a number of legislators today, or maybe not asked, but told certain things. I'll say this. There's litigation already filed around that. It was filed over the weekend, and so there's a request for temporary restraining in the League of Women Voters case. There's a temporary restraining order request, as well as a supplemental complaint with for cause of action. So I don't know how that's going to play out, and I haven't seen that the legislature's taken any action to try and convene a panel yet. Probably.
Oh, I think they have in one case.
They have.
I understand. Yeah.
Okay. Thank you. So anyway, it's an interesting time to watch these things. The other one that already passed that you're already aware of, I think, is Senate Bill 134 that expands the Supreme Court by 2, expands the Court of Appeals by 2, and expands the district courts by 3, 1 each in 3rd, 4th, and 5th districts. So a lot of new resources pouring into the judiciary. Oh, House Bill 392, this isn't written into the bill, but it does, that's the panel process for district court, for these specific district court cases. It does come with funding for 3 dedicated law clerk attorneys to assist the panel, as well as a case manager to assist in the case management of those panel cases. The idea, I think, would be that those individuals' primary responsibility would be to serve the needs of the panel as those exist, whatever that looks like. And then to the extent they're not busy doing that work, they can be retasked so they're not sitting on their hands doing nothing if there's no panel work to be done. So there's a lot of resources in those that we didn't anticipate coming into the decision. Okay. Another one that it has a substitute, and it's, I think, 16 on the House second reading calendar right now, so it's going to get substituted soon, is the Judicial Transparency Bill, as well as financial disclosures, which is part of transparency in their minds, as well as a cooling off period for judges when they leave the bench. That bill is going to be, there now is a publicly numbered substitute 1 for substitute, and it changes the bill. The original proposal was that all court audio in district and juvenile court be made publicly available. And we kind of talked through how there's a lot of sensitive things in those courts that go on that people probably don't need, want, or deserve to have just disseminated publicly with such so little friction. So they're pivoting in the first substitute to say that parties to the case shall have free and expedited access to the audio of their own cases. They would make an audio request, and we would make that audio available to them in an expedited manner. They can already request that audio, but it's not free to them, number one, and sometimes those requests can take a number of weeks to fill because of just, I guess, workload. I don't know, I need to learn more about how long it takes to fill those audio requests generally. The public will still be able to make audio requests as well under its existing processes. But the parties' requests should be expedited, so we'll need more FTEs to do the filling of audio requests for parties for free. So we'll figure out what that fiscal impact looks like. It also requires a restructuring of Exchange, the records access system that we have. For some reason, some legislators, I think in the Senate, feel strongly that the court not do that themselves and that we contract with a third-party vendor to restructure Exchange. And I'm trying to figure out what the concerns are there. It's an interesting proposal. We've not seen a requirement up to this point. That
who has a brother-in-law?
Well, I don't know. I would say it's that, but
You're so sweet.
I'm a super sweet guy.
You are.
I told that by every so we're working on that. The financial disclosures part of that bill remains in the first substitute, and I believe will remain in the bill through passage. They feel strongly that there ought to be required financial disclosures for all judges. It changed from the initial idea, which was that the legislature would just create a system for us, to now say the Judicial Council shall, which you probably love having the Judicial Council shall language in statutes, but it would direct you all to create a financial disclosures process that is comparable with what exists for the legislative and executive branch, and then publish those financial disclosures on a website. And then we report to the legislature in November of this year about the progress that we've made on that, and they'll see if they want to do something different. The cooling off period would require for 2 years preventing a law firm from being able to hire a judge who had left the bench if that firm was involved in suing the government. I think there's a distinct possibility that that entire section of the bill could come out. I think it's okay for me to say that the Supreme Court's been actively working on creating a proposed rule that we would have in our rules, in the code of, or the rules of professional responsibility, that may be sufficient to get the legislators to say, okay, we've got what we need there, and they don't need to have a statute about it.
And it would just, by the way, it would just apply to us. And I think we've talked to the Court of Appeals about, because we understand that for district court judges, it basically means you can't get a job where you live after you retire. So that won't do a lot to encourage people to apply to be judges.
Yeah.
But for us to agree to not appear before the Supreme Court for a period of time after we retire, or for the Court of Appeals to do that, we could probably still work and not do that. But so we're hoping that that will get this taken into the bill.
As written, colloquial phrase that used is a firm can't hire you if they're suing the state, but the language was more broad than that. Yeah. I mean, it would be any firm that has a eminent domain case, a PCR case, a tax case, a pothole case.
Yep.
In other words,
Yeah, and admittedly, had I realized I was gonna be held a 67% retention vote and couldn't get a job when I was done, I never would have applied for this job.
Right.
And I think that's gotta be chilling out there for other people thinking about applying for the job.
Yeah.
Yeah.
No.
It's a discouraging way to structure and encourage people to dive into the work, right? I'm sure you're all feeling that. Do I have a few more minutes? Or do you want me to?
Yeah, no, you're good.
Okay. I wanted to mention two other bills. Senate Bill 270 currently proposes to create a special court with one judge, up to 3 judges, I guess, at some level, but for debt collection and housing cases. And that it would be centralized.
Really it's removing people from their housing. They're not giving people housing in these cases. They are removing people from their housing.
Yes.
Eviction cases.
Yeah, that's the way eviction, yeah. Forcible, yeah, that's right.
You're way too nice.
In Senate Bill 270, that initial creation of this special court would be like a parallel to the Business and Chancery Court or the District Court, its own entity. Senator Cullimore, through some good conversations, has agreed to pivot the bill. He hasn't done so yet, but he talked about it in committee when it was in Senate committee to keep this just in the District Court. Bring some resources into the district court in the form of commissioners and a pool of JAs dedicated to doing this work, and then still trying to centralize this on a calendar that's somewhat like what 3rd District has been doing for quite some time with the debt collection and eviction calendars.
Just out of curiosity, when you're up there, do they have a good grasp between creating a new court and the administration of the courts? Do they have a good firm grasp about the line in between those two things? Because,
Yeah.
and I ask this seriously because sort of telling the courts how to administrate debt collection cases in the district court seems very administrative to me. Whereas creating a new court like the Business and Chancery Court or the juvenile courts seems like it's within the legislature's power to do. There seems to me, and I understand that there's these two different approaches, but one of them seems to be well within their ability, and the other one maybe a little more questionable about their abilities.
Yep, great observation. If the legislature creates their own court, like they did with the Business and Chancery Court, then they can structure in a very detailed way exactly how that work unfolds, the jurisdiction of the court and a bunch of other things, right? And yet it's not typically our desire to have 18 different courts, one for each type of thing that the legislature would like to see done in a particular way. And so then the question is, are they going to administer the judiciary within the district court context? It will depend on how this bill is written in its substitute. If it is written such that they say the district court, currently there's a statute that says the district court can have divisions, right? But the divisions shouldn't impair the functioning of the court. They may take a hook there and say, this is a kind of a division that we would like to see happen, and then go ahead and administer this. And here's some resources. I don't know what this substitute's going to look like. It may be very heavy-handed. Who knows? I'm hoping, though, that it would say, district court, here's this thing, and here's this way to do work that seems like it makes sense. The Utah Bar Foundation, the Utah Bar, the stakeholders, parties, they all seem to think there's merit to this, and there could be merit for us as well if it's resourced correctly. But it does step into that administering. It potentially can step into the administrative court.
Yeah, you're providing us resources and saying, hey, we'd like you to do this thing, and we're going to give you a bunch of resources to do it. So we're encouraging you to do the thing with these resources. It's very different than saying, create some divisions and make them do the thing. And these are all the things you've got to make it do.
It is.
The roadmap for this sort of is in small claims. Small claims is a division. It has, if the jurisdiction is here, there's this. And if you devise this the same way, also then providing the Supreme Court will adopt rules of procedure that will affect these types of cases. Simplified rules of procedure. It's not unheard of doing it, but it is a much tighter road to hoe. It's a much narrower lane than just create this business and chancery thing. Well done.
It's a delicate balance between, again, I think us not necessarily wanting to administer a dozen different types of court, and also not having the legislature directly administer the one. And so I'm not sure how it all plays out, but we'll see how the first substitute looks.
In either case, we're creating a dozen different kinds of courts. It's just a procedural vehicle to do so.
In
We've
some
got a
ways.
constitutional panel and do this, and we've got a debt collection court and do this, and we're still creating a bunch of different courts.
In some ways, yeah.
Yeah.
I mean, in some ways too, it's a reflection, and I think, I hope this feels early. I think it's an appreciation for the fact that Third District has done something really smart and unique in this particular space where there's a real high volume and there's a need to attend to it in a particular way. And so creating these calendars that Judge Parker had and now Judge Stormont and Judge Pettit have, and trying to, I think what they're saying in admiration, like that seems like a workable way to get resources all together in one place. Let's make it apply for everyone. And it's can we figure out a way to do that given the numbers? Like Salt Lake County process is about 48%.
So is it still on a statewide?
They're still looking at filing it at home and funneling it into a specific calendar.
And if you don't resolve it in this calendar and it goes back for trial, it heads home.
Right.
Judge Levitt, did you have a comment?
Well, just on that point, I think this is the kind of nuance we've been really, as a liaison committee, pushing Michael to do. The financial disclosures part is a good example. I think they have no business telling us we have to do this every year. I think it would be within their power to require it as part of a retention election because that is in their bailiwick. And so we do keep pressing back with Michael saying, we're opposing this because it's not in your wheelhouse, but also just because you think it needs to be done doesn't mean we do. And I think we've tried to be very open to, hey, the financial disclosure idea is a good idea, or hey, managing these debt collection cases in this way might be something we can take. But I want us to get away from this idea that they're going to make a statute that's going to force us to do something that's not within their branch's power to do in the first place. And yet Michael has to go into those meetings and help them understand that with a smile. And that's been hard, I think.
That's where my sweetness and my niceness.
Hey, that's okay. You should have it up there with them, but it doesn't mean we have to.
These are hard concepts. There's some hard bills, and I think they know they're hard. I have a number of legislators apologizing to me with how hard the session has been. I'll convey that apology back to you all too. I'm sure it's been stressful. We're over on time, so I want to stop there, but I'm happy to answer any questions.
District bill.
Yeah.
Oh, yeah.
So Senate Bill 308 was actually the last one on the list. It would take our current 8 judicial district structure and combine it into 4 northern, southern, eastern, western districts. The sticky point, I think, right now with the bill, liaison, I think, has voted to be no position on it with some feedback about a few things that probably haven't been thought about. So know that. The use of judicial district, both for the north, south, east, west variety, as well as for second, third, fourth, creates a lot of confusion. Like in presiding judge statute, it says that each judicial district shall have a presiding judge. Well, do they mean the northern, southern, eastern, western, or do they mean the first, second, third, fourth, fifth subdivisions of each judicial districts? It's not clear. The Utah Constitution says that judges shall be retained in a nonpartisan retention election for the district for which they were selected. All current judges were selected for first, second, third, fourth, fifth, sixth configurations, not northern, southern, eastern, western. So it's tricky to understand how retention elections might work.
How about the panel? Will you ever know
The panel of judges is another good one, right? It says that they should be picked so that there's no more than one judge from each district. Is that the first, second, third, fourth configuration, or the northern, southern, eastern, western? We don't know answers to those questions yet. I need to talk to Senator Weiler. This has been assigned to the Senate Judiciary Law Enforcement Committee. It's not on the agenda yet that I can see, but just be having that conversation and trying to figure it out.
Do you have a sense of how they envision this? Like in their ideal universe, how does this work? Like, is it really, I mean, I joke with Jim that I'm really excited for all these judges to join our signing rotation because I have to do it like once every 2 years.
Right?
So is that what they are envisioning, that we kind of collectively are?
I don't know. I think they're envisioning expanding the district footprints for purposes of additional judges being able to apply for vacancies. But I don't know that the vacancies are necessarily going to be filled at the first, second, third, or the northern, southern, eastern, western configuration, or if they're going to have to be filled by first, second, third, fourth, because the statute that says third district has 32 district court judges and 9 juvenile court judges is not getting eliminated. So are they picking judges for the northern district or for the first judicial district? The answer isn't clear. So that's some of the conversation that I need to be having.
And and does it seem like retention votes, how would those work under this?
The retention votes is, again, a tricky question. I think if people just looked at it without, like, at first blush, you think, okay, well, for the northern district, which is all of current first, second, and third districts, those, what is that, 9 counties? Will the voters of all 9 counties will vote on all 51 district court judges as they come around for retention election. But then you look at Article 8, Section, I think 7, on the retention election, and it says judges are retained for the district that they're selected for. So maybe at least currently, judges on the bench continue to be retained for the district, like third district, and the counties in that district.
Lieutenant Governor Henderson's gonna love this.
That's going to be messy if it passes as it's written.
And the Constitution uses the word
Geographic division.
division repeatedly, as the bill uses the word district to have 2 different meanings.
Yes.
Yeah.
And no statute, as far as I'm aware, uses the word division.
Not that I'm aware of it.
And I can't imagine a case being filed in Logan and being heard here in Salt Lake.
Yeah, there's venue issues. as
Right.
well, right.
That
terms
just
of-
doesn't seem like it would work.
I mean, for criminal cases, for instance, right, the statute says that you file in the county or district, when you have like multiple kind of like crime spree or whatever, right, you file a single criminal episode in a particular place. Well, if the district is 9 whole counties, a lot of unanswered questions. And then I think the question is there a clearly articulated need for this sort of confusion to be introduced into our relatively stable current system? So we'll have to figure that out.
Does this seem like something that would pass, or is it maybe just a hobby horse of somebody that isn't going anywhere? I don't know.
Yeah, I think this would pass because I think that the underlying issues and the nuance of it is not broadly understood by legislators. And
So it makes
that's,
it more likely to pass because they don't understand it?
that often is the case.
Okay,
Oh, yeah.
that's interesting.
And there's a strong motivation to diversify the third district bench.
I think in some ways, yeah.
Isn't this more about the going around the constitutional provision that you gotta live in the district where you're a judge, and they want people to be able to be their district judges and live them down?
Yeah, although I don't know if it's going around the Constitution because the Constitution says the legislature can create geographic divisions and if there are divisions.
It's not an end run, but
Yeah,
it's,
Oh, I see what you're saying.
it'd be much, not that it'd be super easy, but amending the Constitution would be cleaner.
Yes. Let them live in an adjacent county. Okay.
Yeah.
All the things. There's a lot of options. We had seen a previous version of this a few years ago, and it had a big fiscal note one time. And this particular version of it doesn't because it preserves the sub-districts that we're accustomed to. And it was raised last summer by a few legislators, but we didn't actually know this bill was going to show up until it was numbered last week. So not a lot of conversation happened between the first version of the bill, a brief conversation in July of last year, and then the bill getting numbered. So it's a lot of unanswered questions.
Any other questions from?
Did anything I say today cause anyone enough concern that you want further discussion and have me correct course on anything?
I would like to say for the record that in previous legislative sessions, you've looked less well than you do today.
Thank you. I'm trying hard to sleep as well as I can.
No, seriously.
No, I mean,
sometimes get.
Here's what it is. Last night at 1 a.m.
That's a compliment.
Thank you. Here's the secret. Last night at 1 a.m., I stopped working on fiscal notes and I went in my kitchen and ate 3 powdered raspberry filled donuts with a big glass of milk, and then I went to bed. That's how you maintain this sort of.
Useful data. It's a great plan.
So if you're struggling, adopt the Michael Drexel plan.
Love it.
Vigor and vitality.
That's really broad. All right. Well, thank you.
Thank you all for your
For your
patience.
rest of your day on this bill.
Thanks.
We'll move to, item, 16, old business, new business. Okay. Good, we've already done. 17 consent calendar, we need a motion.
I'd like to make a motion to approve the items on the consent calendar.
Second.
Any discussion? Abstentions or nay votes? Rule that passes. Thank you for being here. We will be adjourned, and the management committee, we will meet right now in this room.
It's not you. Lunch will be here.
Lunch will be here in 5 minutes.
We only have to use that one.
Thank you.
Thank you.
Next to me.
Are you waiting for lunch?
Yeah, no, I'm waiting for the mute button.
I'm waiting for the mute button. Oh,
We've got, okay. Well, welcome to our management committee meeting today. We have a very short agenda. Appreciate you being here with us. But we're gonna handle two matters, one which is not on our agenda. First is gonna be our council agenda for the upcoming meeting in St. George. And the second is an item, that we'll go into executive session for. As to the judicial council agenda, any updates?
Do you want us to add a report back on the rule for the 3-judge panel constitutional?
Yes.
Okay, so we will add that.
Right?
It will have taken effect, and we can also tell you.
I think we'll have a lot of information.
We'll have a lot more.
We'll know how many pieces it's been invoked in potentially,
Right.
and that which may inform how we move forward. But I think
Right.
it's gonna either go like this or like,
Well, it's gonna start off like this, you know that for sure.
but is it gonna
And
continue?
then it might plateau. We don't know.
Okay.
Yes.
Maybe the one right. Certification of a justice court judge.
Yep.
Well, with those two modifications, I would make a motion to approve the modified agenda.
I'll second it.
Any abstentions or nay votes? That passes. We'll go into executive session. Thank you all.
Thank you.
Then we are adjourned and we'll see you in St. George.
Oh, Maddie, let me share one thing with you before you sign off. You should know this. I'm not going to be at the March meeting. It is going to be there for me. I'm still working with my doctors to figure out why it is that I've had debilitating headaches since June of last year. And there's a procedure that they think might help with that. It's going to take place on March 12th. It was the next available date. These things come up every few months, so I'm just going to take it. I'm just meeting to be here.
Okay.
That sounds eminently reasonable.
And I'll be there by video. I think I've already told you that because my wife would kill me if I left the day before my daughter's wedding.
And you would deserve it.
I would.